ICE is demanding that landlords turn over tenant information to assist in mass deportation efforts. Here's what we know. Several landlords in Atlanta recently confirmed to the Associated Press that they have received subpoenas from ICE requesting complete files on tenants, including rental applications, forwarding addresses, leases, IDs, and other information. Rental applications often contain information such as work history, marital status, and family relationships. The two-page information enforcement subpoena obtained by the AP was signed by an officer for U.S. Citizenship and Immigration Services Anti-Fraud Unit, but had not been signed by a judge. The lack of a judge's signature has raised a series of legal questions regarding the new demands from ICE, with some experts noting that landlords could risk violating the Fair Housing Act if they comply. Enacted in 1968, the Fair Housing Act is a civil rights law that prohibits housing discrimination based on national origin, race, and more. ICE has been known to make attempts at entering residences using subpoenas signed by agency supervisors, though a Know Your Rights campaign backed by a number of advocacy groups has urged individuals not to allow immigration officials into their homes if the request has not been signed by a judge. The subpoena obtained by the AP was issued by the USCIS Fraud Detection and National Security Directorate, which is part of the Department of Homeland Security. Though the document has not been signed by a judge, it threatens that landlords may be held in contempt of court if they refuse to comply with the requests. According to the Immigrant Legal Resource Center, ICE can only require legal compliance with the subpoenas if they file a lawsuit in federal court and obtain a judge's signature for the enforcement order. Homeland Security spokesperson Tricia McLaughlin said that ICE is authorized to obtain records or testimony through specific administrative subpoena authorities. She responded to critics who have expressed concern that the subpoenas are being used as an intimidation tactic that will cause landlords to comply with the order when it is not legally required, stating that it is false to say that subpoenas from ICE can simply be ignored. McLaughlin added that failure to comply with an ICE-issued administrative subpoena may result in serious legal penalties.